irregularities were enough to affect the elections, and therefore they nullified it. After this, there was a perceived feeling that the judiciary is more independent, and also it instilled public confidence, which brings us now to the elections in 2022, where they were more peaceful than prior elections. And this is the time when we cannot attribute anything to that peace, but perhaps we can say that the fact that they had seen that a court can nullify a presidential election, people had more confidence in what the judiciary would decide. And after the judicial pronunciation about this election petition, people went about their business and moved on with life. And in this situation, the Supreme Court did not nullify the presidential election, citing, they also applied, like in 2013, they applied a qualitative test, saying that the irregularities were not of such magnitude to affect the outcome of the presidential election. And so that is in peace. That is how the judiciary has tried to promote peace and to reform. There are different structures of the judiciary under the various regimes. The Chief Justices since 2010 have tried to transform the judiciary and make it an institution that demands public confidence and has judicial independence. They have done this through various strategic plans. For example, Chief Justice Willy Mutunga had the 2014 to 2018 strategic plan. His focus was mainly on justice and service delivery, transformative leadership and organizational management, infrastructure, and financial resources and information, communication, and technology. Under Chief Justice Maraga, his strategic plan focus was on, his focus was more wide, and in my opinion, this is where he tried to bring back confidence in the judiciary. His focus was on access to justice, expediting delivery of justice, growing jurisprudence and knowledge management, improving governance and transformative leadership, improving human capital, efficiency, enhancing public confidence, awareness and image of the judiciary, among others. Now currently there is a 2022 to 2027 strategic plan under Chief Justice Martha Koome, which main areas of focus are efficient, effective, and accountable administration of justice, motivated, professional, dynamic, and responsive judges, judicial officers, and judiciary staff. All this is all to promote peace, but as we saw, there is a correlation between peace and development, especially during election period. And therefore, to test the justiciability of the right to development, Kituo cha Sheria filed a case. It's Nakuru High Court Constitutional Petition number 9 of 2022, Kituo cha Sheria versus IBC and others. This case was a case, the campaign period in Kenya for the purpose of the August elections was to commence on 29th May and was to end on 6th August 2022. But as you are aware, people started campaigning way earlier. From 2017, after the other election, people started their campaign period, and they were campaigning prior to the commencement of the gazetted campaign period. And therefore, this case was filed to try to stop these early campaigns, because the argument was early campaigns increase the likelihood of violence, seen as people are always in a constant electioneering frenzy. And even during the campaigns themselves, on the campaign trail, there is violence. And also, due to this electioneering frenzy, it's not conducive for economic development, seen as tourists will not come in Kenya, there will be no, foreign investors are not trying to invest in a volatile country. Even our local investors are not carrying out their business to the optimum. And this was, as per, we analyzed a report by the Institute of Economic Affairs. There is a graph that shows the years under which, from 1963 to 2014, the GDP growth rates. As you can see from that chart, especially from 1992 to 2013, you can see every election year there is a dip in the GDP growth rate. Perhaps I can get the graph. Yes, you can see that dip during 1992. There is a dip, then it rises. 1997 again during the election period, it dips again, rises until then dips again in 2002. There is also a dip. Then it rises until 2007. There is a dip. Then even coming to 2013, you can see there is a dip of the GDP growth, and these growth rates, the GDP growth rate, the mean average of the election years is 4%. When the election, 2 years after the elections, the GDP growth is actually at 6.6%. And therefore, there is a direct correlation between development and elections and peace. And therefore, the more peaceful the elections are, the more there is development, and vice versa. And because of that, this is the paper is addressing all these issues and the linkage between peace and development in the elections affect peace and development. Thank you.
All right, thank you so much, Nelias. Can we now have Kagema Peterson? Kagema Peterson on the role of the church on something. All right, and then we request the speakers to apply the MISS principle. Do you know the MISS principle? It means make it short and simple. Today we won't do KISS. Keep it short and simple. Now make it, eh? So kindly make it short and simple. Yeah.
Wow, thank you. Good afternoon. Thank you. As you have heard, I'm Peterson Kagema, and I'm here to present a topic that is of recently has been I've been having some interest in it on the whole issues of gender. So with you, okay, first I'm a teacher, high school teacher at Muranga. So I'm very privileged to share with you this platform. So I'm a teacher of history and CRE. So I'm very happy to share you in this platform. Now I'll be addressing or sharing with you the role of the church as a civil society organization in promoting gender inclusivity and justice within the democratic spaces. Now, one of my best topics when I'm teaching students is the topic of constitution making and the part of democracy. So that's one of my best topic that I usually admire when I'm teaching the students. Now, therefore, the issues of the legal issues of rights in such, it's of great importance when it comes to informing people on the needs, issues with gender equality, and having a place to inform. Now, in this case, church as a constituent of civil society organization that has been working very consistently to promote issues of access, that is to ensure that they are accessible, affordable, and proximate ways that promote various forms of social, political, and economic justice across all prayers within the democratic spaces. Now, since the theme of the conference is on the issues of access to justice, as I was looking further, I realized that those three words, accessible, affordable, and proximate to it, those are part of the key foundation when it comes to promoting access to justice. Because if the issues of justice are not accessible, then are not affordable, and are not proximate, in such a way that everybody can be able to access and reachable to all, then we say that there's no fairness in access to justice in that case. Now, the rationale of my topic is the issues of gender. We find that there has been very important when it comes to issues of developments. We find that the role of the role of gender, in this case, both gender, male and females, in contemporary African society is very important in terms of development, because all of us, we need to be there to promote development. So, if you leave one gender behind, it means that development will not be holistic. So, it's important, this topic is very important. I find that in most of the African societies, women do comprise of the majority of active members in the religious, social, and economic spheres. As I was analyzing, especially in the church, you find that women are the majority in the church. If one day you tell all men, priests in the church, come out, leave the church, you find that the church will be left, the number of men will be insignificant. You find that most of the men do not attend church. I don't know why. Don't know. So women are majority in the church. So you find that the same case as I was assessing in the social issues, maybe attending burials, attending issues of shamas, such. We find that women are the majority in that case. So even in economic areas, maybe markets, you go there, you find women are the majority. So therefore, in terms of inclusivity, it's very important. However, that is economic and social areas. What about in political areas? You find that women are not there to be seen. Either they have been set aside, I don't know why, by the various forces, social, economic, and political forces have set them apart. So they are not the majority. So in such case, that informs in that case. Now, such case, they are part of sustaining force of both missionary and visionary objective of every society, including in the family. We find that women maintain the mission of the family, the vision of the family. So it's very important to have such. However, in that case, they have not been controlling the various aspects. Now, in such case, I find that women should be seen as agents of social and cultural, economic, and political growth in their own rights. They have the right to be agents of growth in all aspects. Now, in that case, their exclusion would have adverse impact on various forms of development. So if you find that society excluding women in various aspects, you should know that that society or community will be lagging behind. You find that, as I was looking at some of the community that are not gender sensitive in terms of development, then you find that those communities are lagging behind. The majority of those, therefore, non-inclusivity in women in social, economic, and political spheres leads women to have, in this case, one, inability, low visibility and quality of participation, poor influence in policy and decision making. So having all that in mind, what is the role of various social agents or agents? Like church, what have church prayed to avert the issues of gender inequalities and inclusivity, that is inclusivity in such, within the developing democratic spaces? So one, as I was assessing church as a civil society, I took the theme of issues of civil society, and one, I looked at civil society as a body of members working towards restoring the socio-cultural, economic, and political normality. That is a civil society should also work to rectify the social discriminations, inequalities as perpetuated by socio-economic and political forces, retrogressive forces. So, in this case, how does church work to restore the progressive socio-cultural developments and political developments? What is the role of the church in rectifying some of the retrogressive issues in terms of socio-cultural laws that deny women in active participation? Now, you find that church offers an acceptable foundation for civil action within the church. Now, you find that as a community of the kingdom of God, church promotes moral character of equality and inclusivity. So because the moral character of the church or within the community of the kingdom of God is that all of us are created equally and are the image, created equally in the image of God. So the aspect of equality should apply in terms of gender and within such aspect. Now, you find that Church Corinth as a civil society was enhanced during the Second Vatican Council of 1962 and up to 1965. You find that church was called to be part of world solution makers to the emerging social, economic, and political issues. Now you find that during electioneer period, if you have been find or seeing either church leaders coming out clearly, either to call upon some of the either communities, their respective communities, the government, institutions, and all players to ensure that there is good, equal treatment of all in terms of election, electing all. Now, it has been also, the church has also been sharing information pertaining on human rights. Now, you find that church can provide a very good platform to provide information and ideas. One, that challenge autocratic forms of regimes using its credibility as an independent and morally centered organization. However, the definition of that is how the other people define the issues of morality towards the church. That's relative. In that case, now, also church serves as a school of civil life, helping individuals and local social groups to develop their skills. So it can be a very good platform whereby the church is taking part to inform people, to educate people. And in this case, as we have seen that women are the majority. So where the church takes that role, then women will be so enlightened on their role, place, and such. Now, the role of church in access to justice. Now, you find that we have seen one of the aspects of access to justice is easy access, affordability, and coming up with proximate ways so that everybody can access justice. So you find that church, if properly utilized by the legal institutions, can be so important in terms of reaching people. That's why we talk of affordability and access, because it's at the bottom of the people, in this case, if I may use that. So therefore, the church can use what we call informal methods of justice, informal methods of access to justice, because in the formal part, we find that take the route of the courts. Now, it requires creation of easy, affordable, and quick methods of solving conflict, alternative sources of access to justice. So that has been tried to look at it. Now, you'll find that social civil institutions, such as religious institutions, will be vital as an alternative source of justice. So as we are discussing the issues of access to justice, it's good we look at how are the various ways in which we can access that. Now, I want as I was looking at then, I took a case of Rwanda very briefly. Lessons from Rwanda. Now, I realize that in Africa, Rwanda is one of the countries that have promoted gender equality in inclusivity. Now, hence, it can, one, you'll find that during the post-genocide transitional government from 1994 to 2003, now women percentage representation increased from 25.7% up to 50% in parliament. So you can see up to 2003. Now, by 2021, you find that in Rwanda, women representation in parliament, it increased up to 61.25% in 21. So that's very important. You find that. So however, compared to Kenya in 2021, including the women representatives, we had 24% of women in parliament in Kenya. So it tells you that the discrepancy in terms of women election. Now, what is the secret, as I was looking at, in terms of church, the role of the church in Rwanda? And you find that the place of church is has been so important. You find that various, taking the aspect of faith-based organization. Now, one of the such institutions is by the name HDI and TIAFAD. It's one of the international Christian-based charity organization. Now, it has been carrying out various thematic areas. One, you find that one of the areas that it has been undertaken very seriously, it's teaching people on understanding sexual and gender-based violence and its effect to communities. So the such information is very important. Also, it has been addressing unequal power balance and dynamics and privileges, so to the people, discussing positive masculinity in that case, so that it can work towards eliminating people in the negative masculinity. Also, the biblical equality of men and women before God and all in such case. Now, therefore, in Kenya, in this case, I would propose that when it comes to issues of gender and educating people, especially in gender, let it be addressed thematically. Because you find that where there is some cultures that are not friendly, especially to erecting women. So the church can be used to address that is the issues of gender inequality thematically. One, we have seen addressing the issues of positive masculinity, so that such societies, the male-dominated ideas are taken positively, not negatively. Now, the issues of church and education, that is church and voter education, has been so important. Now you find that, one, I looked at the case of, for example, in 2017, during the 2017 Supreme Court presidential petition, it declared that election is a process. So to me, to promote democratic aspect when it comes to election of women, if there is no proper education when it comes to voter education and sensitization of people, then people will have no information in that case. So a very important part or process will have been omitted. So therefore, issues of fairness or unfairness will be a bit different, or there will be no justice in that case. Now, if I go to conclusion, you'll find that the church, or through various legal institutions, there's need to collaborate. There's need for collaboration of both the church or religious institutions with all the legal institutions to promote inclusiveness of women, so that this will guarantee development. Now, there are various recommendations that have come up with. One is the establishment of an institution whose responsibility is to identify, archive, and provide a comparative achievements of outstanding women leaders to act as a role model. In this case, the church will take part in terms of educating in terms of such. Now, legal institutions should collaborate with the church and other religious institutions to facilitate training of church leaders on various legal issues relating to gender equality and inclusivity. Now, church, in this case, should also act as a role model on gender equality and inclusivity, especially on top leadership. Then the last one is that church as a civil society should collaborate with parliamentarian leadership on equipping women leaders with skills and needed competence that will make them outstanding in social, economic, and political spheres. So that ends my presentation, and thank you.
All right. Thank you so much. Mwalimu wa CRE na history. Eh? Yeah, that's what he said. I'm reminded, I don't know why I dropped history in high school. I just don't know. But later on, I regretted. Francis Hayundi, Dr. Francis Hayundi, Mr. Moses Mushiri, Mr. Joseph Masharia, and Sam Shallow. We have 30 minutes for the presentations that you have. So we are going to do back-to-back, all right? So 10 minutes, 10 minutes, 10 minutes, and thereafter we have the discussion, and then we go for lunch. So, Dr. Hayundi, just come and do the presentation, and let's have it back-to-back. I will not come to the podium again. Then Moses Mushiri and Joseph Mashar. And after that, you will just take the seat. The only seat that you will avoid is the one in the middle, because thereafter it will be occupied by Professor Mbote.
Hi everyone, my name is Spirit Ngari. I'll be taking you through our paper, which is on the role of political parties in promoting constitutional democracy in Kenya. So the principal laws that govern the formation, management, and regulation of political parties in Kenya are the Constitution of Kenya, the Political Parties Act, and then we have other acts like the Elections Act, the National Cohesion and Integration Act, and the Independent Electorals and Boundary Commission Act. So in the Constitution, the articles that we have that speak on the role of political parties in Kenya, we have firstly the preamble, which recognizes the aspiration of all Kenyans for a government based on the essential values of human rights, equality, freedom, democracy, social justice, and the rule of law. Then we have Article 2, which underscores or highlights that Kenya is a multi-party democratic state founded on the national values and principles, including those of governance, democracy, participation of the people, and discrimination and protection of the marginalized. Then we have Article 16, which provides for the membership of political parties and says that members of a political party may be or may include citizens living outside of the country. Then we have Article 36, which provides for the right or freedom of association, and Article 38, which guarantees citizens' rights to make political choices, including the right to form or participate in forming a political party, and to participate in the activities, recruitment, and even campaigning for political parties or related causes. Then we have Article 91, which sets down the basic requirements for a political party. And this includes that a political party must have a national character and respect and promote gender equality and equity, as well as practice democracy through regular, fair, and free elections within the party. And Article 92 of the Constitution of Kenya is the ground on which now the Political Parties Act was founded. And that is what is guiding us on our paper on the role of political parties in promotion of constitutional democracy in Kenya. So the Political Parties Act was amended in January 2022, coming up with very interesting sections like Section 4A now, which lays out the roles and function of political parties in Kenya. And this section was actually challenged. Some people went to court to challenge the constitutionality of some of the sections that were being introduced by the Political Parties Amendment Act, including that Section 4A. In the famous case of the Duranira case, which is petition number, just a minute, which was petition number E043, consolidated with E057 and E109 of 2022. So the roles of political parties include the recruitment and the enlistment of members, nomination of candidates for elections, and they are supposed to promote representation in parliament and county assemblies of women, persons and with disabilities, youth, ethnic and other minorities and marginalized communities. They are also required to sensitize the public on the functioning of political and electoral system, as well as promotion and enhancement of national unity. They are also supposed to mobilize citizens into participating in political decisions, soliciting and articulating public policy priorities as identified by members. And they also have the role of shaping and influencing public policy. So Francis will take us through the other parts on the practice of political parties and whether they have been able to promote constitutional democracy in Kenya.
All right. Good afternoon, ladies and gentlemen. Yes, of course, this is something that we started thinking about. We know the role that elections have to play in today's society, particularly in Kenya, where it's a zero-sum game. So when we talk about the role of political parties, in addition to the ones that we have in the Political Parties Act, there are other attendant roles that political parties play, because we have seen how political parties fight to win the elections, and of course with that they get to choose or nominate parties to other arms of government. And therefore, our argument is that when you consider some of these roles and functions, not just the ones listed in the Political Parties Act, but also the general role that politics has to play in Kenya, then they can play a huge role in constitutional democracy, particularly promoting it. And so some of the areas where we suggest that political parties have a role to play, of course, is when you consider the system of checks and balances that we have enshrined in our Constitution. We cannot underestimate the role of the legislative arm of government, whose members are largely gotten from political parties. On top of that, of course, there are other instances that we can talk about. For instance, the 2/3 gender representation that still seems to be a challenge for political parties. I think there was an earlier presentation on the situation in Tanzania, but we still see it today, that instead of political parties promoting gender issues, women are pushed to go for certain seats that are set aside for them, as opposed to having competition on an equal basis. Then, of course, another area we can talk about the role of political parties is appointment to certain offices. Whereas certain appointment to certain offices is supposed to be based on merit and qualification, we are seeing an increasing trend where politicians are being picked to positions, and of course we are told they are no longer politicians until they start carrying out their functions. Another role, of course, and this I think is more of early warning and prevention, is the system of nomination of political parties. Of course, on the run-up to the elections, we saw there was a bit of a standoff between the IEBC and political parties in terms of who can run and cannot run for political office. And so our argument is that when we see, or when we sit down and think of the important role that political parties play, especially given what functions they have immediately after they get into power, or even if they do not get into power, what they can do to influence constitutional democracy, of course, through the functioning of other arms of government. Because another interesting thing, of course, that is recent, we have seen attempts to amend the Electoral Commission, Independent Electoral Commission and Boundaries Act, where the amendment proposes an additional role for political parties. And of course, when it comes to appointments made by political parties, it is always the numbers. And sometimes this can have a big influence on the working of other institutions that promote constitutional democracy. And I think we can also agree, in light of Kenya's experience in the past, particularly the contestation of outcomes of elections, political parties have a role to play in promoting peace, because how they get their members to respond or to behave themselves once we have certain election results announced is really indicative of whether they are the kind of parties to promote constitutional democracy or not. Of course, when we look at the provisions of the Constitution, read together with all these acts that were mentioned, the Political Parties Act, the Elections Act, we can see that there is a role for political parties to play. But our argument is more needs to be done by political parties. And of course, if this is done, we look at the bigger picture, then it is possible to promote constitutionalism or constitutional democracy, of course, which is underpinned by aspects such as the rule of law, access to justice, equality, equity, public participation, and so on and so forth. So we shall end there, and of course we welcome your comments. Thank you.
Thank you so much, Dr. Aura and the Follap team, for this invitation to this third milestone National Conference on Legal Aid and the opportunity to present my paper. Kindly project it. On a duty of care theory for elections management bodies in Kenya, where I'll be making a case for a novel duty of care in the election processes. So this paper attempts to construct a special duty of care theory as a basis for which elections management bodies, principally the IEBC in Kenya, while performing its constitutional and statutory mandate, could be held legally accountable and therefore liable. So I will be attempting to do this by exploring the broader question whether election management bodies should and can be held liable under a novel duty of care theory for failure to manage elections in accordance with the prescribed constitutional threshold. It goes without saying that elections in elections, there is no more important institution than the electoral agency. But in recent times, IEBC has also been harshly criticized as the key author of Kenya's fake democracy, quote unquote, or that Kenya's democracy dies at the altar of the IEBC. Now, the wisdom behind the unequivocal vesting of such vast and important electoral powers and functions on a single monopolistic body has been questioned, with some key observers noting that no one body should be allowed to play God with a franchise, especially in Kenya. Whether you agree with the quote in the slide before is a matter of opinion. But what we can agree on is that elections are not just about numbers, but the processes. And that the integrity of the electoral process is not just important, it is everything in view of the magnitude, significance, and import of national election. Consider the holding in IEBC versus Minor KI, that because elections determine electoral political winners and losers, electoral processes from voter registration through to declaration of results have long been targeted for manipulation. And that, with emphasis, lack of trust among political parties and players and suspicions of electoral fraud have in the past catalyzed polarization and triggered ethnic conflicts in nearly every election cycle. So that from a legal standpoint, the law is settled on the scope of electoral process, and that is the start and end point from the eyes of the law. These are the processes, the aspects of which and the details of which are within the direct scope of control of the IEBC, and which are the focus of this paper. So that antecedent processes like political party nominations and primaries, funding of political parties, campaign financing is beyond the scope of this paper. Moving on, yes. The zeitgeist of Kenya's elections history, pre-2010 constitution era, 1992, 97, 202, and 207, is one that can be characterized as tense and prone to corruption, ineptitude, opaque processes, and in some rather low moments in Kenya's history, violence, unlike any that we have witnessed before. But ex post the 2010 constitution, thankfully, we are witnessing gradual improvement in key elections processes, in tallying, transmission of results, the use of technology with its challenges, and public participation, including gender and other achievements. But there are still huge gaps, and that require intervention, both pre, during, and post-election, especially in the matter of procurement processes for printing ballot papers and electronic kits, tallying of votes at the CTC, the constituency tallying centers, transmission of results to NTCs, verification, deployment of technology. As we think about this, the process is circumscribed by Articles 81 and 86 of the Constitution. In the 2017 petition, Odinga versus IEBC, we had Maraga Justice, as it then was, saying that whatever voting method is used, the system must be simple, accurate, verifiable, secure, accountable, and transparent, open and accurate collation of results, and that the structures and mechanisms to eliminate electoral malpractice are put in place, including the safekeeping of election materials. Moving on. So we need to have a synopsis of a novel duty of care jurisprudence in elections management. So recent decisions in the Kenya Supreme Court in presidential election petitions reveals the emergence of a subtle duty of care jurisprudence, especially based on the notion of trust in electoral processes. Trust. Justice Ndungo's dissenting opinion in Odinga versus IEBC in 2017 brings this out clearly, observing that electoral processes have assumed a fair presumption of correctness. Think about that for a minute, that electoral processes have assumed a fair presumption of correctness. To rebut that presumption requires a proof to a high degree that resulting declaration is not trustworthy. So the question I pose to you is that whether the outcome of an election is capable of being trusted to reflect the will of the people. Those cases that are in that slide reflect that relationship of trust as it is brought out on the duties of the IEBC. Let's move on. So in Raila Odinga versus IEBC 2017, it was emphasized that the duty upon the commission to verify the results before declaring them, and to ensure that the results declared are the ones recorded at the polling station, not to vary, change, or alter the results. But importantly, that apart from that duty to verify, it is the responsibility of the IEBC to ensure that the system of voting, counting, and tallying is verifiable. The 2017 Odinga decision demonstrates to the world that, contrary to popular view, the results of an election in terms of numbers can be overturned if a petitioner can prove that the election process was not conducted in compliance with the principles laid down in Article 83 of the Constitution. So what is the common thread in all these Kenyan presidential election petition cases? That an election is an elaborate process. That process begins with registration of voters, all the way through to nomination of candidates, voting, counting, tallying of votes, and finally declaration of the winner. These are huge questions. When senior counsels in these petitions were asked to clarify the difference between counting and tallying, or the difference between a ballot and a vote, that's where these issues come into play. And therefore, the concept of free and fair elections is expressed not only on the voting day, but throughout the election process. And any non-compliance with the law regulating these processes can affect the validity of the election. Revisiting the theory of duty of care. The duty of care refers to circumstances and relationships which the law recognizes as giving rise to a legal duty to take care. Students of duty of care theory know that some relationships already have an established duty of care, either by statute or common law, for instance, between motorists and pedestrians. But then there are special instances where there is no precedent, and it is left to the court's discretion to determine whether a duty of care would arise in a given situation. Now, these are known as novel situations. The theory of duty of care was established, of course, in English common law in those cases. I will not go into the detail on them, but only to highlight that the current law, as far as the duty of law is concerned, rests with the Caparo case, which is that case down on the bottom of the slide, the 1990 case, which established a three-stage test that harm was reasonably foreseeable, that there was a relationship of proximity, and that it is fair, just, and reasonable to impose a duty of care. And then moving on, we ask, can we have a duty of care on public authorities? As a general rule of thumb, and as a matter of public and legal policy, generally no liability is imposed on public authorities for omissions to perform statutory duties unless, one, the duties are expressly prescribed in statute, a special relationship exists, and that there is actual potential breach of human rights. So there is a very famous UK case that established that indeed public authorities can owe a duty of care. And that is the case of Michael versus the Chief Constable of South Wales Police and other cases. In order to succeed in negligence action, it is not enough to demonstrate carelessness or injury. Important. You must show that there was a duty of care that was owed. Moving on. And again. So then, if we apply the Caparo test to justify a novel duty of care by elections management bodies, we ask the questions. Are duties expressly prescribed in statute? Yes. We have the various articles in the Constitution, the Elections Act, and the Elections General Regulations thereunder. Does a special relationship exist? IEBC has a special statutory monopoly, which impacts directly on the rights, the political rights of citizens. It is a relationship that is based on a sacred trust that is implicit in the legal framework? And thirdly, is there a risk of actual potential breach of human rights? Yes, Article 38 answers that question. That the very existence of IEBC and the constitutional safeguard of its independence from interference by anybody or person is a direct reflection of Thomas Hobbes and John Locke's social contract theory, that when we consent to give up our power to these bodies and to the government, those powers have a sacred trust to exercise that power on our behalf and in our interest. Then, the mere existence of statutory duties, importantly, in and of itself, is not sufficient to establish a duty of care against a public authority. The Caparo test must be applied to its logical conclusion, and therefore that IEBC owes a notional, contingent on foreseeability of harm, duty of care to manage electoral processes. This has been established in Maina Kiai case and Odinga in 2017. That IEBC is in a position of control, statutory oversight over the broad spectrum and minutiae of all aspects of details of the elections processes. And thirdly, that assumption of responsibility applies and harm is foreseeable, and therefore the constitutional threshold of free and fair, transparent, accountable, credible, and fair, verifiable elections is a sacred duty that IEBC must dispense. This would probably explain why the Maraga court went the way it did, and to our surprise, why the Mutunga court did not do it in 2013. So, justifications for a novel duty of care for elections management bodies, limited alternative remedies. Consider this, that judicial review has very limited application, if any, in presidential election petitions. The Supreme Court has both original and exclusive jurisdiction. There is a unique statutory monopoly, which creates a unique relationship which amounts to a novel duty of care and trust between IEBC, political parties, the judiciary, and us, the people. And that thirdly, the unique standard of proof that was confirmed in Odinga versus IEBC, that election petitions is higher than a balance of probabilities, but not beyond, thank you, reasonable doubt. Let me conclude. The practical utility of a proposed novel duty of care by election management bodies is that it links together all the constitutional and statutory principles governing administration of elections. It provides a legal filter through which actions and exercise of discretion by the IEBC can be scrutinized, and provides an operational legal theory against which the IEBC can conduct and dispense their constitutional and statutory duty. I have tried to establish that public duties can owe a duty of care in special circumstances, that a trust relationship between IEBC and the Kenyan people exists, and therefore that election management bodies hold these powers and must exercise them in trust. By embracing this duty of care standard, at the very least, it provides a conceptual legal theory to add to the arsenal of arguments in election petitions in future, especially presidential election petitions at the Supreme Court, where these sort of policy arguments bear most weight. Thank you so much.
Good afternoon. My name is Mashalia. I'll be co-presenting with Sam Chalo. We understand we are the last group to present, standing between presentation, lunch, and us. We'll try and save time. First, by not tiring your eyes, we do not have a slide presentation. We'll also try and tie in what other presenters have talked about as it relates to our presentation. We'll be presenting on democratic consolidation and weak parties in Kenya, and we offer socio-legal perspectives. So we do not intend to present, or our paper is not one of normative approach like Mr. Moses Moshiri has done, but rather a positive paper that analyzes what's currently going on, trying to diagnose what causes or what exactly causes weak political parties and the motivations behind it. We proceed on the premise that entrenchment of right to associate and political parties in constitution is an important foundational step to coalescing of ideas, political persuasions, and compromised divergent views. Political parties formed in political, social, and economic space are lifeblood of democratic systems of government worldwide. They obviously provide socio, political, and economic platforms and governance institutions. Although multipartism provides a solid foundation on which constitutional democracy could function by, for instance, discouraging dictatorship and militarism, we know that improperly founded political parties, whatever the number they are incapable of advancing constitutional and democratic principles. In Kenya, we observe, and Dr. Kayundi had already alluded to this, that constitutional intendment of political parties is to have empowered political parties so that they advance democratic and constitutional values. However, more than a decade, the reality of political parties in Kenya remain relatively the same, characterized by weak parties defined by personalities that are easy to mutate. Then we ask ourselves, why is it that with such a robust constitutional and legal framework produce no transformative-like, or indeed serious noticeable outcomes? Put differently, what is really enfeebling political parties in Kenyan polity despite having a progressive constitutional framework? We understand and appreciate that a number of articles have been written and argued about the legal framework. We, however, as we agree that the legal framework assessment is a productive analytical approach to assessing performance of political parties, we argue that the problem lies elsewhere. And if we were wrong that the political legal framework is it's actually the problem, we could reach the same conclusion even if we were to assess the political parties as they exist versus what the law provides. We have argued, me and Sam, we have argued elsewhere that, which are theory we intend to explore as relates to political parties, that institutional inefficiency in Kenya is intentional and by design that creates a private market with the buyers and sellers and has beneficiaries. So we take a similar approach. So we therefore locate our political parties' failure outside the legal framework, and in this case, in socio-political culture. We make two arguments. One, transformative political provisions, such as the one we have in our legal system, can only thrive in what we call pro-constitutional environment. And if this pro-constitutional environment is not there, such provisions remain illusory, unimplementable, and could demonstrate the limits of constitutions, or what Professor Mbote called limits of formal law in producing meaningful constitutional change. We observe that as it relates to political parties, Kenya lacks or has inadequate pro-constitutional political parties environment. This failure, we contend, has its beneficiaries. In other words, we are not victims of social and political naturalness, but what quote-unquote annoying, all quote-unquote annoying but mum participants of an intentionally designed system by political actors for self-sustenance and preserving their shelf life. Therefore, weak parties, as they exist in Kenya, are designed to fit in that socio-political environment. As I quickly try to characterize political parties, what features, currently, in what environment, how do they appear? We say that pre-election period appears to be a peak period for people registering new political parties. All, for those existing ones, it's a chance to reinvent themselves, either by branding, forming coalitions. And the question we are asking, why does this happen? We argue that this mutation in the sense that they keep changing, is haphazard, uncoordinated, and appears to follow no certain process of or ideology. We also argue that we observe that individuals overshadow political parties rather than political parties overshadowing individuals. So if you were to mention a certain political party, there's someone who comes to mind rather than having a political party and then the political party system is able to sift or assess or produce an individual who therefore meets the political party's ideologies. We also observe that there is no fundamental difference ideologically between the political parties, at least the main political parties. So that if you were to, for instance, try and differentiate between one political party and another, you'd have difficulties trying to assess what exactly ideological identity do they produce. We will be arguing that that flexible lack of ideology is actually an intention so that you allow people to easily move from one party to the other and allow political quote-unquote conmanship because it allows selling and buying of political affiliations. I think political parties draw numeric strength from communities or geographical regions, and their support coincides with senior political officials in a certain party. And it also appears that there is a strong correlation between party leadership, promised benefits to those politicians, and the support base. And we are asking, if we genuinely have political parties, does it mean that in some specific regions, people tend to have similar ideological views, so that one region seems to have a different views of another? Is it possible? And even if we were to assume that that is possible, is it possible to have a super majority support base in a certain area? Couldn't we entertain 20, 30% of supporting a different ideology? So based on that, some will be trying to demonstrate the intention that the political parties, the weak political parties that we currently have, are actually by intention and by design. Thank you very much.
Thank you very much. I'll take at most 3 minutes. I hope I'm not being ambitious. Macharia has taken us through the background around political parties in this country and has alluded to reasons why they are weak. And I quickly want to talk about the legal framework within which these political parties work and what really does the Constitution expect of political parties. I'm lucky because Dr. Kayundi and Ms. Purity Ngari have taken us through a very terrific account of the law and the role of political parties. So I'm only going to mention one article of the Constitution, which is Article 91, which we argue is the main constitutional provision regarding political parties and outlines basic requirements that political parties must adhere to, and these include, among others, upholding national unity and respecting and promoting human rights and constitutional principles and the rule of law. So These principles did not exist before the 2010 Constitution. Indeed, the 1963-1969 constitutions did not have any mention of such principles, and we argue that this would implicate many other constitutional provisions that have been talked about before, including Article 10, and including even principles of democracy and constitutionalism that are implicit. So political parties are placed at the nucleus of the democracy. They are consolidators of our democracy and have to act as a link between the people and the state, as opposed to being outfits for the elite. So why then, if you have such a strong constitutional framework that anticipates very strong parties that care about constitutional and rule of law and democratic principles, why then do you have weak parties? And we have looked at the CKRC report, for example, outlining the problems that were there before the 2010 Constitution, including what they called briefcase parties and parties formed for personal enhancement, which we argue persists. And we've also talked about the decision of Thuranira versus Attorney General, which considered the constitutionality of the 2022 amendments to the Political Parties Amendment Act. And there we focus on what the court said regarding political ideology, that political parties must have specific ideology in order to be able to promote democratic principles. Then, as to why then the parties are weak and what really enfeebles them, Macharia has alluded to many factors, and I'm going to just focus on one, which is not having a pro-constitutional environment and lack of pro-constitutional behavior among political parties within those parties, and within those political parties, and constitutional scholars writing on pro-constitutional behavior have said that pro-constitutional behavior would entail having respect for constitutional principles, democratic principles, even when those principles are not expressly stated. In other words, you expect that actors will take certain actions that will end up facilitating the implementation of values and commitments that are expressed or implicit constitutional texts. And really, to back the point that has been mentioned by Macharia before on why political parties and political personalities cannot be differentiated in the current form, we'd have to consider why, for example, the Orange Democratic Movement has had one party leader for such a long time, why the UDA alliance has had one leader for the time it's been in existence, and whether such a party would continue being in existence without such a leader. And we argue that this demonstrates use of political parties as what we call political insurance to protect their power and influence. And ultimately, we argue that this is not a legal problem. It's not a problem with the constitutional statutory framework that we have. It's a problem that lies deep in the political culture, and to be able to effectively make any reform here, we don't necessarily need reforms to the law. In fact, having the laws that we have is a good thing, because at the very least, it serves an educational role, which would be a catalyst. And with that, we end there and welcome your comments. Thank you very much.
Thank you so much. I always thought that every time we talk about the duty of care, it must always be followed by that other of skill. I thought they always go together, the duty of care and skill. Anyway, today I've been shown that we can actually split them. I would like to make a proposal. It's now 1:45. If we could go for lunch, then come back, and the first session we'll have once we come back is that of the discussion led by Professor Mbote, and then now we move to the afternoon presentation. Is that okay? Is that okay? Yeah. All right, so if that is okay, I will also make a proposal that as we go out, just before we get in for lunch, we will take a group photo down there, all right? By the time you get there, the photography team and every other person who's concerned will have gotten there, and they will be ready to take the shots. Ni sawa sawa? Asanteni sana. Who has the meal cards? So you'll pick your meal cards outside there. They are with the Florida Musi. Thank you.